You're going to trial. Do you want a judge or a jury to decide your case? Hi, I'm Northern Virginia criminal defense attorney Scott Nolan, and I'm here to talk to you about judge or jury. The first thing to know is that you may not have the choice. In Virginia, if either the defendant or the prosecution demands a jury, then the trial will be by jury. So even in some cases where you might wish to avoid a jury, you might wind up with one. So in most cases, you're going to prefer a judge trial over a jury trial. This is particularly true if you're representing yourself. Self-represented defendants are required to obey the exact same laws as lawyers are. In other words, you need to know what you're doing, and if you're not a lawyer, that can sometimes be difficult. You need to know how to request a jury, how to question a jury, how to impanel a jury, how to select a jury. So having said all of that, how do you decide between a judge or a jury? Well, there is no hard and fast rule. Many lawyers, including myself, follow a rule of thumb that says if your case has an emotional component to it, you want a jury. If it is a technical case, you want a judge. That is, if there's an element of the case that might be more about perception and feelings than it is about the law, many lawyers will agree that a jury is better. An example might be where, yeah, you committed the crime, but most people would agree that wasn't a bad thing under the circumstances. That's obviously pretty rare, but that's a good time to have a jury on your case. See my other video about jury nullification. But it might also simply be, look, you're not guilty, but the reasons you aren't guilty are all about your intent. And if your intent is something that was emotional, if your intent is something that is going to either appeal to or shock a jury, then it's probably something you want a jury to decide. For my own purposes, I also think that juries simply have better bullshit detectors than judges. Not because judges are bad, but because judges hear the same kind of evidence over and over and over again. And they may be inclined in some cases to conflate your case with the similar case they heard last week or last month. And therefore it sort of flattens out any emotional aspect of the case. And because of that, I think you're simply better off with a jury. Also, a jury is composed of 12 people, or 7 in the case of a misdemeanor appeal. And I generally think that the life experiences of 7 or 12 people are going to be more informative about you, the average citizen, than will the life experience of someone who, after all, is a lawyer and spent much, if not most of their time in court. On the other hand, if your case is a technical one, Judge, I am not guilty because they violated my Fourth Amendment rights. Or, I am guilty, but this is a matter of necessity. This is a matter of duress. Some technical defense. Then I don't think juries care that much about technicalities. If this is a case where you should be found not guilty for some technical or legal reason, then you don't want the emotions of a jury involved. You probably do want a cool-headed judge to be looking at this. That certainly is the rule of thumb that one will hear from many lawyers, and for the most part, I tend to agree with it. The only place that I sort of disagree with that rule of thumb is when it comes down to there's 2 stories and they're both kind of equally good, yours and the prosecution's. In theory, ties should go to the defense, but I worry that one man or one woman is the judge is going to see that a little bit differently, and that you are probably better off with a number of people looking at that case. And so I really do think that ties, I personally would choose a jury over a judge. If you'd like to talk about juries versus judges or any other aspect of the law, please feel free to give me a call. I'd be happy to talk to you. And you have a great day.